Hello and welcome. This is class number 2 of the questions marathon for Prelims 2025, or in other words, your crash course to revise before the Prelims 2025 arrives. I hope all of you are doing good and you watched the first class where we discussed 25 questions from Indian Polity. We'll continue with Polity in this class and discuss another set of 25 questions to help you revise. A lot of you watched the first video. If you did not, please do go and watch that. It's available in the same playlist. Also, please keep a track of how many questions are you getting right and let me know in the comment section what exactly is your score. Again, reminding you, if you want the PDF of these classes, you have to join the Telegram channel. The link is in the description of the video. Also, download my app. The description contains a link of my app as well, where you can find other courses as well. This particular course will have the first few classes on YouTube, and then the entire course will be available for you on my app, that is Harshmeet Study Circle app, where we will be completing this course till the end of April, and we'll have over 1000 questions that we will discuss. Let's begin. 25 questions were discussed in the first class. We are beginning from question 26. With reference to provision of the Indian Constitution, consider the following. The term secular was included in the Preamble through 44th Amendment in 1978. Now, all of you would have read the Preamble of the Constitution has only been amended once, that was by 42nd Amendment, where words such as socialist, secular and integrity were added. So, first is wrong. Then, Preamble is enforceable in the court of law as an integral part of the Constitution. Now, Preamble is a part of the Constitution, as the Supreme Court had said in the Keshwanda Bharati case, but it is not enforceable in the court of law. The Preamble reflects the aims and aspirations of the Indian polity, which is absolutely correct. The Supreme Court has also said that the Preamble is the key to understanding the minds of our constitution maker. So, in that sense, the third statement is correct. The answer here would be B. Only the third statement is correct. The first and the second ones here are wrong. Question 26, or rather, sorry, this should be 27, but an extra question for you. Consider the following statements regarding legislative powers of the Parliament of India. The Parliament can legislate on a subject in the state list if it is in the national interest, and Rajya Sabha passes a resolution to that effect. Absolutely right. Rajya Sabha has one of these special powers. They can empower the Parliament to make a law on the state list as well. Now, in the comment section, tell me, Rajya Sabha for such a resolution requires which particular majority? So, what majority is a Rajya Sabha required, or does they require to pass such a resolution? The first statement correct. Law passed by Parliament on stateless subject during national emergency ceases to have an effect 6 months after emergency is lifted. Very important part. Many people forget to remember this. If the Parliament makes a law on a stateless subject during national emergency, it's not a permanent law. When the emergency goes away after 6 months, the law will also go away. So, this statement here is also correct. Residuary power of legislation are vested with the Parliament under the Indian Constitution, again correct. Residuary power means if there is a subject which is not found in any of the three lists of the 7th schedule, union, state or concurrent, then it is considered as a residuary subject. That automatically will fall into the laps of the Parliament. For example, let's say cryptocurrency. Now, cryptocurrency or these kind of things which are new emerging technology which have not been mentioned in the Constitution, they come under residuary powers. The answer here will be D. All the three given statements here are correct. Next question about fundamental rights. Which of the following is or are explicitly prohibited under Article 15? So, Article 15 prohibits what? Discrimination on the grounds of religion, race, caste, sex or place of birth. Access to shops and public places being denied based on social status. Protective discrimination in the favor of scheduled castes and scheduled tribes. Now, protective discrimination is another way of saying reservation. Means, see, when you are reserving certain seats or giving certain preference to people, that means it's a kind of a discrimination only. But you're doing that to protect them. So, it's a protective discrimination in favor of scheduled caste, scheduled tribe. This is allowed as per Article 15. The Constitution are asking you what is prohibited in Article 15. So, first and second are correct. These two are prohibited. Third one is allowed, not prohibited. The answer thus becomes B. 1 and 2 are correct. The third statement here is wrong. Next question. With reference to financial relations between center and the state, consider the following. The distribution of taxes between center and the state is determined by the Finance Commission, Article 280. Yes. As you know, Finance Commission is established by the President of India once in 5 years or even earlier if the President wishes, and they will suggest to the central government from the income that they have had from the taxes how much to be given to the state governments. Recommendation of Finance Commission are binding. No. They are not binding, although they are usually accepted by the government, but they are not binding. The grants and aid provided to the states under Article 275 can be used for any purpose. Now understand, the central government gives a lot of money to the states under various categories. One of the categories is what the Finance Commission suggests. Apart from the suggestion given by Finance Commission, the central government also gives certain amount of money to the states. For example, you would have seen the central government announcing special package for certain states. Those are grants in aid. They are given for a specific purpose. For example, let's say there is problem of flood in a certain state. So central government might give money, but that money specifically has to be used for flood relief work only and can't be used for any specific purpose, any random purpose. So third is wrong. The answer thus becomes 1 and 2. I don't think there is 1. Right. Sorry. The answer is 1 only, because second also is wrong. The answer thus is B. Only first statement here is correct. Next question 29. Consider the following about governor's rule. The governor may reserve a bill passed by the state legislature for president's consideration under Article 200. Correct? As you know, the governor has this power. If they want to delay a certain bill or they think the bill is too important, then they can send it to the President of India. Governor must act on the advice of the Chief Minister while appointing the Advocate General. See, whenever the governor of a state is appointing any executive position in the state, they have to do that on the advice of the Council of Ministers, that is the Chief Minister only. So second is correct. Governor is the ex officio chancellor of all state universities. This is also correct, although certain states are now taking this back. West Bengal, for example, has now passed a law that does not allow the governor to become automatically the ex officio chancellor, but many of the state governments still continue with this provision. The answer thus will be all three are correct, that is D. 1, 2 and 3, all three are given correct statements here. Next, with reference to national emergency, consider the following. Number 1. Proclamation of national emergency requires approval of both houses within 1 month of issue. Yes. So national emergency is 1 month. State and financial emergency, for those it requires an approval of both the House of Parliament within 2 months. Fundamental rights under Article 2021 can be suspended during national emergency. No. As you know, there are 3 categories of fundamental rights with respect to emergency. 20 and 21 are those which can never be suspended. Article 19 is automatically suspended if it is external emergency. Others can be suspended on the orders of the President of India. So that is how the category has been put. President can revoke proclamation of national emergency at any time without the parliamentary approval. Yes. So national emergency can be removed or revoked either by the President's order or if the Lok Sabha passes a resolution by a simple majority. So answer here would be 1 and 3. That is B. Second statement here is wrong. Next question. Which of the following requires a special majority under the Indian Constitution? Removal of a Supreme Court judge, yes, requires a special majority. 2/3 members present and voting and 50% total. Passing constitutional amendment bills, yes, and approval of national emergency, yes. All these 3. For other 2 emergencies, they require a simple majority. And even for revocation of national emergency, simple majority is required. But for accepting or approving the proclamation, special majority is required. So the answer here is D. All the 3 given statements, 1, 2 and 3 here are correct in this particular question. Next, consider the following statements about relationship between directive principles and the fundamental rights. Number 1. Fundamental rights have precedence over directive principles in case of a conflict. Second, the Minerva Mills case emphasized a balance between fundamental rights and directive principles. And third, directive principles are enforceable in a court of law. Now please understand, Usually the Supreme Court has accepted the fact that both of these should be respected together. They have to coexist harmoniously. Even if you look at Article 31C, it talks about priority order of fundamental rights and directive principles. However, overall there is acceptance over the fact that fundamental rights are more important than directive principles overall. So first statement is considered correct. Second is also correct. In the Minerva Mills case, Supreme Court said that there should be a balance between the two, but if we have to choose, fundamental rights would take the precedence. Third is wrong. Directive principles are not enforceable in the court of law. We discussed this earlier as well. These are all in the form of suggestions or advice. The answer thus becomes A. 1 and 2 are correct and not the other way around. Next question 33. Which of the following amendments to the Constitution does not require ratification by at least half of the state legislatures? As you know, when a federal feature of the Constitution has to be changed, half of the state legislatures also have to give an assent by a simple majority. Which of these is not that situation? Election of president, it requires the state legislature assent. Representation of states, again it does require. Changing the official language, this is specifically power of the parliament. The states have no role to play here. So the answer here is B3 only. In the other two, you do require at least half of the states also to say yes. But when it comes to choosing the official language of the country, the parliament alone will have to take the call without the state having any say in that, because it's not a federal matter. States, as you know, have their own official language. The state governments can choose that language by themselves. Next, about the special status of J&K. With reference to erstwhile, means at the time that it existed, the erstwhile special status of Jammu Kashmir, consider the following. Article 370 allowed J&K to have its constitution, yes. The governor of J&K was appointed by the legislature of the state, no. The state governor of Jammu Kashmir was appointed by the President of India, just like in other states. Constitution of India did not apply to Jammu Kashmir in its entirety, yes. That was one of the most contentious provisions. Not all the provisions were applicable to Jammu Kashmir, like for example fundamental duties. They were not applicable to Jammu Kashmir when they had a special status. The answer thus becomes B. 1 and 3 are correct. Second statement here is wrong. Next, about the money bill. There are three statements. First, money bill can only be introduced in the Lok Sabha. Yes, all of you know this. Speaker's decision on whether a bill is a money bill is final and binding. Now, this is actually correct. You might say Supreme Court has said that if the question or the decision by the speaker is not objective, if it seems to be biased, and they may look into it, but overall still there is acceptance over the fact that the decision of the speaker on the money bill has to be final and binding unless it is prima facie malified. Rajya Sabha cannot suggest amendments to money bill. This is wrong. Now, they can't make changes to the money bill, but they can still suggest. The suggestion part is still open. The answer thus becomes A. 1 and 2 are correct. Rajya Sabha still is capable of giving the suggestions, if not making changes by themselves. Next, question 36, anti-defection. Under the 10th schedule of the Constitution, which of the following would not lead to disqualification? Okay, would not lead to disqualification. Voluntarily giving up membership, yes, it will lead to disqualification. Voluntary contrary or voting contrary to the party whip, yes. Forming a new party after merger of 2/3 of the original members, this is something that will not lead to disqualification. See, anti-defection law does give certain exceptions which protect you from disqualification. One of this is this provision, that if you are part of the 2/3 members that want to remove or want to go away and form a new party, that is allowed. Earlier it used to be 1/3, now it's at least 2/3. The answer thus is B. 3 only will not lead to disqualification, while the first 2 will lead to disqualification. Next, President's ordinance making power. Which of the following is true about the ordinance making power of the President? Number 1. An ordinance has the same force and effect as the act of the Parliament. Yes. Ordinance can be issued only when both the House of Parliament are not in session. See, now this is where you have to understand. An ordinance can be issued when at least one of the houses is not in session. Only when both the houses are not in session, this is actually wrong. It can be issued if at least one house is not in session. Ordinance ceases to operate if disapproved by either house of the parliament. Now this is tricky. See, when an ordinance is passed, what happens here is the parliament, after it reconvenes, has to pass it within 6 weeks. If they don't pass it within 6 weeks, it goes away. Now, if the parliament wants, can they remove it before the 6-week period is over? Yeah, they can. But for that, both the houses have to reject it. So both the houses have to say that we are rejecting it. Then the ordinance will cease to exist before the 6 weeks period is over. So the third statement also actually is wrong. The options here don't seem to be correct. The answer has to be one only. None of the options here are correct actually. Sorry for this error. But second and third both are wrong. Second is wrong because even if one of the houses is not in session, ordinance can be made. And ordinance, if it has to be cut short before 6 weeks also, both houses of the parliament have to reject it, not just one. So for this particular one, the answer should be one only. This is where we have to make a correction. Next question. With reference to Article 32, consider the following. The right to constitutional remedies under Article 32 can be suspended during national emergency. Now please understand, I told you earlier as well, Article 32 can be suspended, yes, because only 20 and 21 are not suspendable during national emergency. The other ones, including Article 32, can be suspended. Now, many students have this doubt that what if Article 32 is suspended, then what is the use of other fundamental rights? But you don't understand the fact that Article 32 gives you the right to approach the Supreme Court. So even if it goes away, you still have Article 226, so you can still approach the High Court. This is where Article 32 can be suspended. Article 32 empowers the Supreme Court to issue the writs for fundamental rights violation, yes. It is a fundamental right in itself, yes. It is a part of Part 3 of the Constitution. The answer thus is D. All the three are correct. It can be suspended. So you can go to High Court during emergency if it is suspended, and in this case, Article 32 in itself is a fundamental right. Next question. All union territories are governed directly by the president through an administrator. We discussed this statement in the first test as well, the first session as well. This is wrong. Not all are directly administered because we have a legislature in certain union territories. Parliament can provide a legislature for a union territory through a law. Yes, they have done that for Delhi, Puducherry, J&K. All UTs have representation, Rajya Sabha, no. So only the UTs that have a state legislature of their own, that is Delhi, Puducherry and J&K, only these three have a representation, Rajya Sabha, others do not. So the answer here becomes B. 2 only is correct. The other two statements, 1 and 3 here are wrong. The first statement also is incorrect. So the answer here is 2 only. Sorry for this. Second statement only is correct. Next question 40. Which of the following judgments establish the principle that fundamental rights and dietary principles are complementary to each other? We discussed this statement just a few questions back. It was in the famous Minerva Mills case of 1980, in which it was declared that fundamental rights and dietary principles are complementary, so they should try and complement each other. And then later on it was decided that if there has to be a clash, fundamental rights have to be given the preference over the others. Next question about UPSC. The composition of UPSC is determined by the President of India. Yes, Constitution does not give any clarity on that. Usually there are 9 to 11 members, but at least, for example, even today there are not 9 members. It is set by the President of India. UPSC is consulted on matters related to appointment promotion of all civil servants. Yes. Decisions of UPSC are binding. No. Decisions of any of these commissions are never binding on the government. They are all in the form of suggestions. So the answer here will be A. 1 and 2 are correct. The third statement here is wrong. Next question 42 about the Attorney General of India. Attorney General has right to audience in all courts within the country. Yes, this is one of the special provisions Attorney General has. Attorney General is appointed by the President and holds office till the pleasure of the President. Yes, because they don't have a specific procedure for removal. Attorney General cannot engage in private practice while holding office. Now this is wrong. They can engage in private practice with certain restrictions. For example, if they are defending an accused in a criminal case, they have to take the government's permission. If they are and also they can't fight a case against the government of India. So there are certain restrictions, but they can engage in private practice as well. There is no bar on that. The answer thus will be 1 and 2. Third statement about private practice is wrong. Next question 43 is about legislative councils. Creation or abolition of legislative council requires a constitutional amendment? No. So this is one of the few things in the constitution that you can change, but it is not called a constitutional amendment. It can be done by a simple majority itself. Members of council are directly elected by the people? Wrong. As you know, 1/3 members elected by the MLAs, 1/3 by local bodies, 1/12 by teachers, 1/12 by graduates, and 1/6 by the governor. That is nomination. Third, council cannot reject a money bill. Yes. With respect to money bill, their powers are very similar to that of the Rajya Sabha. So the answer here is D. Third statement only is correct. First and second are wrong. This is wrong. Only 3 is correct. First and the second statements here are wrong. Next, about tribunals. With respect to tribunals in India, consider the following. First, tribunals are mentioned under Part 14A of the Constitution. Correct? Decisions of tribunals are not subject to judicial review by High Court. Now, this is wrong. In the L. Chandra Kumar case 1997, the Supreme Court had said that tribunals are not at par with High Court. If they were at par at High Court, then their appeal will only go to Supreme Court. But the Supreme Court has said that no, your first appeal will have to go to High Court and then you can come to Supreme Court. So second is wrong. Tribunals have both judicial and quasi-judicial functions, which is correct. So they are quasi-judicial bodies as well, and they have the function of a judiciary as well. The answer thus is B. 1 and 3 are correct. Next, question 45. Which of the following statements are correct regarding residuary powers? 1. They are vested with the union legislature, that is a parliament. Correct. Constitutional residuary powers is influenced by the American model of federalism? No. So in America, rather, it is the states that are more powerful. Our residuary power concept, that is residuary power with the center, is based on the Canadian model. So most of the things in our federal system are based on the Canadian model actually. Subjects such as cyber law, space exploration are under residuary power, which is correct. As I told you earlier, the new subjects which have not been mentioned in the constitution by default, like cyber security, etc., cryptocurrency, those are in the residuary list or residuary subjects category. Answer here is B. 1 and 3 are correct. Second is wrong because it is a Canadian model that we are based on. Next question about Lokpal. With reference to Lokpal and Lokayuktas Act 2013, consider the following. Lokpal has jurisdiction over Prime Minister of India with certain exceptions. Yes. So Prime Minister decisions about foreign policy, about space, nuclear program, etc., those can't be questioned, but others can be questioned by the Lokpal. Members of Lokpal appointed by Section Committee chaired by President of India? No, chaired by the Prime Minister. They are appointed by the President, but the committee that is formed is headed by the Prime Minister. Lokpal has suo motu powers to initiate investigation. Means, can they start investigation on their own? Now, this is interesting. They can start investigation on their own as well. The answer thus is A. 1 and 3 are correct. Suo motu means by itself, even without anyone registering. Now, as you know, the first Lokpal that India had was P.C. Ghosh, Pinaki Chandra Ghosh, appointed in 2019. Interestingly, he has left the position, and for a long time, for many months now, we don't have a full-time Lokpal. One of the judicial members has been appointed as an acting Lokpal. So we don't have full-time Lokpal right now, which is a pity. Question 47. Consider the following statements regarding imposition of President's rule in the state. First, President's rule can be imposed if Governor submits a report indicating breakdown of constitutional machinery in the state. Correct. Proclamation of President rule must be approved by both houses within 3 months. No, within 2 months. During the President's rule, the state legislature is dissolved. Now, not essentially. Please understand, When the present rule is imposed, the state legislature can be dissolved or suspended. The difference being, if they are suspended, then after present rule goes away, the same government will come back to power. But if they are dissolved, after present rule goes away, there will be new elections. So there are two options, not just one. The answer thus is B. Only one is correct. Second and third here are wrong. Next question 48 about Legislative Council. Which of the following is not a feature of the Legislative Council in a state? It's a permanent body, can't be dissolved, yes, just like the Rajya Sabha. 1/3 members elected by local bodies, yes. It can delay ordinary bill passed by Legislative Assembly for up to 3 months, yes. So up to 3 months in the first instance, and if it comes back again, they can again delay it for 1 more month. It can reject a money bill passed by the Assembly. This is wrong. It cannot reject a money bill. It can only delay it for 14 days, or it can offer certain suggestions. The answer thus is D. 49. With reference to President's rule, consider the following. Imposition of President rule requires approval of both houses within 2 months. Yes. Once approved, it can continue indefinitely. No. So usually continues for 1 year. Under certain circumstances can continue for 3 years. Now here I have a homework for you. Tell me in the comment section, is there a situation, or was there a situation in India ever that President rule went on for over 3 years? Don't tell me Jammu Kashmir, because that was governor's rule. Tell me amongst the other states in India, has there ever been a situation where the President rule went on for over 3 years? And if yes, then how was that possible? If the constitution only gives a 3-year time limit, then how was it possible? Do tell me that. Anyway, so second is wrong. Judicial review is barred under Article 356. No. All the 3 different forms of emergency can be challenged in the Supreme Court under 44th Constitutional Amendment. Judicial review is open for all the 3 types of emergencies. The answer thus is B. Only first statement is correct. Last question for today's session is about Finance Commission. 1. It's a permanent constitutional body, not permanent. Permanent means it will never be dissolved, but that is wrong. Once it gives a report, it is dissolved. Then after a few years, the next one is established. It recommends measures to augment the consolidated fund of the state to supplement the resources for panchayat and municipality. Yes. So tells the state how can you improve your earning as well. Its recommendations are mandatory? Never. None of these recommendations of the commissions are mandatory. The only commission whose recommendations are mandatory are delimitation commission. Otherwise, all the commissions that we study, they are not binding. The answer thus is B. 2 only is correct here. First, it's a permanent. No, first also is wrong. This again answer is wrong. It's a constitutional body, but not permanent in nature. Sorry for the few errors that we have, but if you're paying attention, we have corrected all of these here. Which brings us to the end of class number 2. Now this was class number 2 of this long series that we will have. The next class will be out tomorrow, will be on ancient history. After a few classes, we will now move this entire series on my app, and you can purchase the course if you want to, if you think it is helpful for you. Over the course, we will have over 1000 questions discussed till the end of April, and you will get all the PDFs here so that you can revise later on as well. Thank you so much for joining in. Do hit the subscribe button if you have not done so far, and do tell me your score in the comment section. Thank you so much. Bye bye. Jai Hind.